It's been a while since we talked about the Capitol Hill protest and the resulting criminal cases that came about as a result of what happened on January 6th. But we do need to dive in just a little bit here. And so we've got a couple things that I want to address. Let me see what's going on with these slides here. So first and foremost, let's jump over here. And I want to show you this guy. So this guy posted this on Twitter. His name is Scott McFarlane, and he is notifying us that we have this going on. So the DC Medical Examiner releases the causes of death in the U.S. Capitol insurrection. So we see here, Ashley Babbitt, this is from them, says Ashley Babbitt here. Oh my gosh, my slides are all out of whack. Ashley Babbitt died of a gunshot wound to the left anterior shoulder. The manner of death was homicide. Kevin Greason, 55 years old, how did he die? Hypertensive atherosclerotic cardiovascular disease, which I think George Floyd actually had. So he had a heart attack and he died. He was 55. Benjamin Phillips also died, also had hypertensive atherosclerotic cardiovascular disease, and the manner of death was natural for him. So we have somebody who was shot by the police. We have somebody who died of a heart attack. Somebody else died of a heart attack. Somebody else, Roseanne Boylan, 34, died of acute amphetamine intoxication. So an overdose, manner of death was an accident. So we've got two people who died of a heart attack, one person who basically overdosed, and then we had somebody who died because the police shot them. And the cause and the manner of the death for Capitol Police Officer Brian Sicknick are still pending. And so we don't know what killed him. And so the DC Medical Examiner apparently posted that today. I saw that by Seth MacFarlane, and so it got me thinking about these Capitol Hill cases. What is going on with them? And so I want to start with this story over from the Washington Post. Says here that some of the Capitol Hill detainees have been beaten up by the guards. Not much of a surprise there, but here we can see Capitol riot detainee alleges beatings by the D.C. jail guards. A man accused of assaulting a police officer at the Capitol alleges that two guards in D.C. beat him up last month, breaking his nose, dislocating his jaw, and leaving him suffering seizures, which is just absolutely reprehensible. When you're in government care, you should be cared for. An attorney for Ryan Samsel, who's 38 years old, detailed the allegations in an interview yesterday on Tuesday, saying he has been told the incident is under investigation by jail and federal authorities. So we'll see where that goes. This is unjustified, said attorney Stephen Metcalf, and the way that these guys are being treated is completely unreasonable. It's wholly unconstitutional, and I couldn't agree more. It doesn't matter what these guys are being charged with. All of these guys are still in pretrial detention. They have not been convicted of any crimes, and this is what they're forced to endure. In a statement, DC DOC said the jail, quote, takes the safety and well-being of all residents extremely seriously. We are aware of the allegation made by an inmate, and it is under investigation by the DOJ, which is exactly right. This attorney's dead right. Doesn't matter what you've been charged with. Okay. We have the presumption of innocence in this country and due process, which are two critical components of our justice system and our country in general. And so just because a certain segment of this population hates Derek Chauvin or hates Ghislaine Maxwell or hates the Capitol Hill rioters, they still deserve a defense. They still deserve the presumption of innocence and due process, and to not be treated in a cruel and inhumane way pursuant to the Eighth Amendment. And so getting housed in a federal corrections facility and then getting your jaw dislocated, your nose broken, and suffering seizures is not appropriate. It's illegal. It's a crime in any sense of the idea, and it's not appropriate. And unfortunately, if you are a person who is in a disfavored class, this happens to you. And some people say it's the Capitol Hill people. Some people say it's African-American people in inner cities, right? But if you're a disfavored class, you get dumped on. And it's not right. It's wrong across the board. It's wrong here. It's wrong when it happens elsewhere. And it irritates me. Lyra Gallagher, somebody who is a spokesperson for the FBI Washington field office, said the Bureau is aware of the allegations, but we can neither confirm nor deny the existence. All right, thanks. Thanks for nothing. According to Metcalf, the incident, as related to him by the client, began the afternoon of March 20th. Samsel complained the guards had taken hours to get him toilet paper. An argument ensued. That evening, according to Metcalf, Samsel was moved to another cell. Around midnight, the lawyer said two guards came to that cell, restrained his arms behind his back with zip tie handcuffs, and beat him to a bloody pulp. Samsel did not regain consciousness until the next day, according to Metcalf, and has since suffered seizures for the first time in his life. His nose was allegedly broken, jaw dislocated, vision in one eye damaged. Metcalf said he saw Samsel by video 2 weeks later. His client's face was still black and blue, and the skin around his wrists was stripped off because he was in zip ties and he was fighting. This is happening in the United States in federal custody. This guy is innocent. Currently, he hasn't been convicted of anything. Not a thing. He's in court. Judges aren't letting him out, apparently. He's alleged to have committed a crime, but he has not been convicted. And he's getting wrecked by guards in D.C., in America. Metcalf, who is representing other alleged rioters, said he heard of the alleged beating from them and has spoken to other inmates as well. A second attorney for Samsel, Elizabeth Pascalini, said she separately learned of the alleged incident from other attorneys for other defendants in the unit. Metcalf said he's in the process of learning the facts, including seeking Samsel's medical records, and had not reported the incident to the police. But he said his client complained at the jail. According to one of Samsel's other attorneys, had been transferred to a different facility. So why didn't he report to the police? Yeah, he's going up the chain of command. Okay. So in detention since late January, Samsel has been there. The Bucks County, PA resident is accused of using a barricade to push an officer outside the Capitol, knocking her unconscious. According to prosecutors, Samsel then offered to help the officer back up and said, "We don't have to hurt you. Why are you standing in our way?" She later collapsed while arresting another rioter and went to an emergency room where she was told she suffered a concussion. Later, according to court records, Samsel attempted to take a riot shield from an officer. She was on parole at the time of the riot, according to court documents. Details of the case were not immediately available. He is charged with assault on a police officer, obstruction of justice. He has not contested the detention. Other inmates have complained through their attorneys about conditions in the D.C. Central Detention Center, but no others have alleged assaults by the guards. The first raised by another alleged rioter, Ronald Sandlin, who said on Tuesday he'd been threatened with violence by the staff here, and even making the statement is putting me in danger of violence and retaliation. So that's what's going on. Not letting them out of custody, then beating the hell out of them. So that's great. We also have, though, some good news, because there is good movement. Remember, we talked about this previously on the show, that a lot of these people who've been charged with crimes, they are not getting bail. They're not being released out of custody. And many of us were scratching our heads watching these orders come down. Jacob Chansley, the QAnon shaman, and all these people. Bail denied. You stay in custody. For what? For trespassing? They didn't hurt anybody. They didn't kill anybody. You know, these people, a lot of them came in after the fact. Many of them weren't even there on January 6th. We talked about two cases. Somebody showed up that night. Somebody showed up the next morning. They're both being charged and lumped in under the Capitol Hill riots because this is a political prosecution. They're not going to let this thing go. They are so jacked, is so enthusiastic about the power that prosecuting these cases will give them, politically speaking, because they're going to be able to use the Capitol Hill protests as a bludgeon for the foreseeable future for everything. We already see it, right? White supremacy, this, everything that, whatever. So as that was happening, we're all scratching our head going, wait a minute, Derek Chauvin's out on bail. Kyle Rittenhouse is out on bail. A lot of other people who are responsible for murder, sex assaults, kidnappings, all these things, they're out on bail and just roaming around the countryside. But little grandma, who is just poking around the Capitol building going, whoa, this is crazy. We're here. This is wild. What's going on? She is a dangerous threat to society and she cannot be released from custody. Why? Because it's political. That's all it boils down to. And it's very inappropriate in this country. Supposed to be equal justice, the scales of justice, right? Not Trump people get blasted and all the Antifa people get diversion plea agreements and their charges dropped and dismissed a year later. It's not how it's supposed to work. It should be equal, but it's not. So even though the Capitol Hill rioters were getting dunked on by the prosecutors and many of the judges that exist in our federal system, fortunately, there is a judge who recognized when too much is enough already. Enough is enough. So this is him. This story comes over from the Politico, says Capitol riot defendants notch a win at the appeals court. In a bail ruling, D.C. Circuit Court says nonviolent participants in the breach may not pose an ongoing danger. Prosecutors are pursuing a massive investigation at the Capitol riot, suffered a setback on Friday as a federal appeals court ruled that two defendants currently in pretrial detention may in fact be entitled to release. The ruling from the D.C. Circuit is its first in a set of sprawling cases stemming from the January 6th storming of the Capitol, been eagerly awaited by prosecutors and defense lawyers as a signal of how the appeals court plans to proceed. This case involves a mother and a son who were charged in the riot. Lisa Eisenhart and Eric Munchel may not need to be jailed in advance of their trial because they pose no danger during the Capitol assault. District Court failed to demonstrate. We're going to read some of that. We're going to go into the actual opinion itself, so I'm not going to cover that here. Other D.C. Circuit judges on the cases, Trump appointee, said he would overturn Howell's decision and instructed her to release the pair with conditions. So we got a concurring opinion. So let's just jump into it. All right, let's take a look here. Wilkins wrote, all right, so let's get to the opinion. So here it is. The United States Court of Appeals for the District Court of Columbia. So this is the D.C. Circuit. The United States of America is the appellee. We have Eric Gavel Munchel, who's the appellant, and they're appealing this up because there was denial of bail. So let's go through this. This is actually really, really interesting. And I want to spend a little bit of time on it. I know it's a little bit of heavy lifting. We got a little bit of reading to do, but just bear with me as we go through it. So this was signed off on by Wilkins, the circuit judge. They're considering an appeal of a pre-trial detention order. So remember, many of these guys sort of voluntarily turn themselves in. And the question is, as the case is pending, can we let them out of custody? Okay. And what we're typically asking ourselves, is this person a danger to the community? Are they going to go out and cause another insurrection? Are they going to go out and kill somebody? Are they going to go use drugs again or commit another crime? Are they going to flee the country? Do they have any local support? And so the default in this country is you are innocent until you are proven guilty. The presumption of innocence reigns supreme, which means that should carry over when you are still innocent unless you're proven guilty. So as somebody is being charged with a crime, the default, in my opinion, should be we let them out. They're still innocent. How does the presumption of innocence have any effect or weight if we just house everybody who's alleged to have been charged with a crime? So it should be the default is we're a little bit more lenient with some of this stuff. Let's take a look at what's going on here. The facts, as found by the district court, have observed there was a 50-minute video of the incident. They're going to walk us through it. Eric and his mom were participating at the protest. He previously worked as a waiter. He's been twice convicted for misdemeanor possession of marijuana in Georgia. Mom is a 57-year-old resident. She has been employed as a nurse for approximately 30 years, has no prior criminal history. Right, a nice nurse. On January 6th, they both went down to the Stop the Steal rally. Both wore tactical vests. Munchel had a taser holstered on his hip. He also wore his iPhone on his tactical vest, used it to take video of the day. They marched towards the Capitol. As they approached the Capitol, they milled around outside and talked with others. They met members of the Oath Keepers militia, and Michael bumps fists with one of them on video. They have the video, the full thing. At some point, while they were standing around, someone yelled, "They broke the line up there," and people began saying, "Let's go in. We're going straight to the federal prison if we go in there with weapons," somebody said. So Munchel responded that he would not go into the Capitol, and they suggested that they put him in their backpacks because they had some weapons on him. They moved to a crowd. The backpack was stowed. Munchel stashed a fanny pack in the backpack, and so they unloaded their weapons. He says the only weapon in the fanny pack was a pocket knife. The government suggested other weapons could have been inside, perhaps even a firearm. Munchel kept his taser holstered on his hip. Subsequently, Mom encouraged others to enter the Capitol, saying the tear gas isn't bad, repeatedly stated, "Let's go in." Munchel and Mom pushed their way through the crowd to continue towards the Capitol. Munchel followed, so son followed Mom, often holding on to a strap on her back. En route, Mom encouraged a man who claimed to have punched two of them in the face, telling him, "While everyone else is on their couch, you guys are training and getting ready for it." Next up, we have Munchel told members of the crowd, "We're not playing effing nice, blah, blah, blah." They entered the Capitol through an open door and stayed inside for 12 minutes. Police officers were standing to the right of the door, not blocking their entry. While walking through the Capitol, Munchel told members of the mob, "Don't break, no vandalizing. We ain't no damn Antifa. You break it, I break you," is what he's saying, right? Additionally, while inside, Munchel and Eisenhart spotted plastic handcuffs known as zip ties. Upon seeing them, she shouted, "Zip ties! I need to get me some of them MFers." They made their way to the Senate gallery, both carrying the zip ties, still carrying his taser. And there are pictures of this guy, right? Munchel in the Senate gallery with the zip ties. I think this is that same guy that image is going around. Inside the gallery, he chanted, "Treason, treason." He looked around the dais and said, "I want that effing gavel," referring to the Senate gavel. We've got a lot of video here. Eventually, they leave the Capitol. As they were leaving, Munchel said to nearby officers, "Sorry, guys, I still love you." On the evening of January 6th, Metro PD stopped Munchel, seized his taser. The next day, they packed their car to go home. Both mom and son spoke to the media. They said this country was founded on revolution. If they're going to take away every legitimate means from us, and we can't even express ourselves on the internet, we won't be able to speak freely, what is America for? I'd rather die as a 57-year-old woman than live under repression. I'd rather die and would rather fight. We've got a footnote here. On January 5th, a police officer observed the taser on Munchel. All right. So then we move forward and we see that I dropped my clicker. Later, Munchel and Eisenhart returned to Tennessee. They continued on to their home in Georgia. FBI posted the pictures on the internet, asking the public to identify them, which happened. On January 10th, FBI agents executed a search warrant on their apartment. They found all of the vests, tactical things, and loaded magazines, firearms, all that stuff. Soon after learning about the search, Munchel turned himself in, so he wasn't there. He also made arrangements for his attorney to give the iPhone to the FBI. So full cooperation. Mom learned that she was also the target of the federal investigation. She spoke to a local FBI agent every day to determine whether there was a warrant for her arrest. And then when the warrant was issued, she self-surrendered. So they both turned themselves in, basically, and fully cooperative. Munchel and Eisenhart were charged with a number of different charges: unlawful entry, violent entry, civil disorder, conspiracy. Munchel and Mom had pre-trial detention hearings before Judge Frensley in Tennessee. Frensley, first judge, said neither one of them were flight risks, nor did they pose a danger to the community, and issued release orders for both appellants with various conditions, including home detention, GPS monitoring, refraining from possessing firearms or dangerous weapons, and supervision by pre-trial services, which is very common. This is all pretty common. This is even, in my opinion, a little bit overkill, but all right, this was a big thing, right? January 6th was a big deal. These guys were in the Capitol building, so you can be a little bit strict on them. A regular trespass case, like if you just were in a government building, maybe you wouldn't get all of that. Home detention, ankle monitoring. Anytime you're charged with a crime, firearms typically go away. Supervision by pretrial services is pretty clear, right? It's somebody you check in with on a regular basis. You're doing your stuff, not in violation of the laws. All right, we're going to let you go out. So first judge says, okay, we're going to let you out of custody. Guess what happens? Magistrate Judge Frensley then briefly stayed both of his release orders, which means he kind of put the hold on them. He granted them. He said, I'm going to let you out. Then says, I'm going to put a stay on those, because the government promptly appealed both orders to the U.S. District Court. They didn't like that. They did not want them out. Chief Judge Beryl Howell stayed both release orders pending the appeal. So they stayed in custody. Both appellants were going to be transported to D.C. COVID-related complications slowed the appellant's transport to D.C. So they're not going to let them out of custody. Then they're not going to transport them to D.C. While their transports were pending, Eisenhart moved to rescind the stay or to conduct an immediate review of her detention, which Munchel joined. The government filed motions seeking review of Judge Frensley's release order. In the meantime, both of them were detained. So all of this is happening. Look at this footnote. So footnote number 2. Even though Judge Frensley had found that the government had not met its burden of proving dangerousness by the standard of clear and convincing evidence, the government sought and obtained an ex parte stay of that release order that resulted in them being detained for 3 weeks without any court finding of dangerousness. Notwithstanding the statute's mandate that review occur promptly and the statutory constitutional requirement of a dangerousness finding. COVID-19 delays caused the delay in the transport to D.C. The record does not indicate why a district court judge could not have heard this matter prior to February 17th, even if the appellants were in another location. Ultimately, this issue, while troubling, is not presented as a ground for reversal in this appeal. So the court is just noticing this separately. These people are put in custody. The underlying judge said, you're free to go. We're going to let you out. You've got to do GPS monitoring, ankle monitoring, pretrial services, can't possess a firearm, don't return to the scene, all that stuff. Great. Perfect. We'll be back here. Mom has no criminal history. Son has some lower level misdemeanor stuff. Nobody injured anybody. Nobody broke anything as far as we can tell, which we're going to get to here in a minute. Of course they should be let out, like any other defendant would. Government, new Department of Justice, hyperventilation mode comes back, and they have to go out there and appeal this. They do not want to let them out at all. Higher level court judge agrees. Says, well, we're not going to let them out while this is pending. That's just going to take 3 weeks. So they sit in custody, even though the law says that there has to be a dangerousness finding under the U.S. Code. And this has to be done promptly under the U.S. Code. The government went around the defendants, had an ex parte hearing, meaning that they wanted to ask the court specifically not to allow them out, probably said that, they were a danger to national security or whatever, that justifies the ex parte hearing. So they go do that. Judge says, all right, we're going to keep them. So you have 2 people with a presumption of innocence now sitting in custody with no due process at all. On February 12th, then, a grand jury sitting in D.C. returned an indictment. They charged Munchel with obstruction and all of the different charges, said he was armed with a dangerous weapon. District Court arraigned Munchel. On the indictment, government made oral argument and a motion for pretrial detention. During this new detention hearing, the government proceeded by proffer rather than by calling live witnesses. In addition to what has been presented, the government introduced a 50-minute videotape into evidence and proffered that after January 6th, Munchel was in contact with a suspected Proud Boys member and was told that he was, quote, too hot after he expressed interest in joining the group. Following the detention hearing, D.C. judge ordered both of them to be detained pending trial. Said that their motions seeking to rescind the stay of the first judge's order are denied as moot. The government's motion seeking review is also moot. District Court concluded that both of them were eligible for detention. Why? Because they were charged with felonies while carrying a dangerous weapon, explaining that the indictment says that he carried the taser when he was trespassing. So that's it, right? That's it. That's the justification for it. So the District Court said that they were not flight risks, but the detention was appropriate based on dangerousness. District Court concluded that their history and the characteristics weighed against detention, but that the nature and circumstances of the charged offenses, the weight of the evidence, and the potential danger that they pose weighed in favor of the detention. District Court determined that neither was likely to be deterred by release conditions. And we've covered a lot of this, right? We've talked a lot about this. Basically, they're using that conduct to justify not letting them out. They're not looking at their priors. They're not looking at any of the normal indicia of release. They're just saying, no. What they did was so dangerous that we're not going to consider those other things. And then we see here, mom and son appealed. They said that the district court erred in not, and this is where we're going to sort of come to a conclusion on this, or I'm going to walk you through this quickly. They appealed. We're now in the Court of Appeals in the D.C. Circuit. What are they claiming went wrong? So let's break this down. They contend that the district court erred in not deferring to the first court's findings. So the first court said they should be let out. Second court said no. They say that the second court erred. This court says, we don't even care about this, so we're just going to get rid of all this. That's not relevant to this. So that issue is done. Next issue. They also contend that the district court inappropriately relied on a finding that they were unlikely to abide by release conditions because that factor is only applicable in the revocation of pretrial release. This court says also irrelevant. Nobody cares. That doesn't matter. Okay, they say basically this is the wrong standard and it's not applicable here. So what's the next issue? All right, so now we know that none of that matters. Next, we're here. They also argue that the charged offenses do not authorize detention, claiming that felonies involving a possession of a weapon rather than use do not qualify for detention, and that the taser is not a dangerous weapon. So they're saying that, oh, no. You can only be denied release if you are using a weapon in the commission of a felony, not being in possession of it. You got to use it in the felony, not just have it on you. This court says, don't even care about that. Actually, we did look into this, and yeah, you can be charged for simply being in possession of a weapon. It does not have to be use, so they're getting the wrong standard there. But even though they lose on all of these prior claims, they say, we also object, they're also objecting to several other defendants who have gotten a better deal than them. So they're saying that their conduct of those is indistinguishable for them or even worse. And then lastly, they're saying that they contend the district court determinations were clearly erroneous as to the findings of dangerous. And this is the real one that the court weighs on, right? And let's go through this. So they're saying here that in this case, they found that they have both of them have limited criminal history. Eisenhardt has none. Their history and characteristics weighed against the finding that no conditions of release would protect the community. In other words, they should be released. District court found that the nature and circumstances of the offense and the weight of the evidence and danger to the community all weighed in favor of a finding that no conditions of release would protect the community, which is nonsense, as we're about to see. The crux of the reasoning, this is why the district court said so. The grand jury said that they used force to subvert a democratic election and arrest the peaceful transfer of power. Such conduct threatens the republic itself. Indeed, few offenses are more threatening to our way of life. So you see how that goes, right? The egregiousness of the conduct was so bad that they're not going to let him out. They say in media interviews, he showed no remorse. She would rather fight than die. They were in danger. The republic was in danger. Nevertheless, we conclude that the district court did not demonstrate that it adequately considered, in light of all the record evidence, whether they presented, and this is where it's important, an identified and articulable threat to the community. Accordingly, we remand further for fact-finding, which means they're going to send that back down to the lower level DC court, and they're going to tell them that they got to dig in and find more facts about this. And I want to just show you, I know this is going long. We got a couple more things I want to get to. It says here, why is it? Why do they need to find more facts? The crux of the constitutional justification for preventative bail, and the government must prove by clear and convincing evidence that an arrestee presents an identified and articulable threat to an individual or the community. Then, only then, a court may disable the arrestee from executing the threat. This comes from a U.S. Supreme Court case called Salerno, and you can see this right here. This U.S. means that's a Supreme Court case. Therefore, to order a defendant preventatively detained, a court must identify an articulable threat that is posed by the individual. The threat does not need to be physical violence. It may extend to non-physical harm, such as corrupting a union, which may be like, leading an insurrection, but it must be clearly identified. What is the continuing threat? It needs to be articulable and clearly identified. So the question is it here? Here, the district court did not adequately demonstrate that it considered whether these two pose an articulable threat to their community. Why? Because the district court based its dangerousness determination on finding that the alleged conduct indicates that he is willing to use force to promote his political ends. So it's basically reading his mind. He was willing to do it in the past, so we're just going to hypothesize that he's going to do it again in the future. In making this determination, however, the court did not explain how it reached that conclusion, notwithstanding the countervailing findings that the record maintains no evidence that while inside the Capitol, Munchel or Eisenhart vandalized any property or physically harmed any person. In fact, the opposite. They were saying, don't break stuff. And the absence of any record evidence that either one of them committed any violence on January 6th. They didn't. They assaulted no one on January 6th. They did not enter the Capitol by force, and they vandalized no property. Are all factors that weigh against the finding that either pose a threat of using force to promote their political ends. Because they didn't use force on January 6th. They were just there. The district court says, they should reconsider that. If in light of the lack of evidence, the district court finds that they do not in fact pose a threat to committing violence in the future, the court should consider this finding in making its dangerousness determination. In our view, those who actually assaulted police officers and broke through windows, doors, and barricades, and those who aided, conspired with, and planned or coordinated such actions are in a different category of dangerousness than those who cheered on the violence or entered the Capitol after others cleared the way. Which is exactly what we've been saying here. Exactly what we've been saying. Yes, everybody needs to be prosecuted, but there's one category. I call them buckets here. He calls them categories. I say one bucket of people who deserve a little bit higher scrutiny, and most of these other people just don't. And this is a good example of that. This is the last slide from this segment. It says, it cannot be gainsaid that the violent breach of the Capitol was a grave danger to our democracy, and that those who participated could rightly be subject to detention to safeguard the community. In times of war or insurrection, when society's interest is at its peak, the government may detain individuals whom the government believes to be dangerous, but we have a grave constitutional obligation to ensure that the facts and circumstances of each case warrant this exceptional treatment. Accordingly, we conclude the appropriate resolution of this case is to send it back down to the lower level court for reconsideration on pretrial detention. So very good news for that. The absolute right ruling on that case. And all of these cases, really, none of these people should be held just on the basis of their political ideology. If there was some level of dangerousness, that's justification. But if it's just they were involved in a political protest and they might do a political protest again, that's not enough. Ham-handed is in the house. So these questions come over from locals.com, watchingthewatchers.locals.com if you want to submit a question or a comment or even a criticism. That's fine too. Ham-handed says, how do you think the defense is going to use hospitalization? We're in the wrong segment. All right, ham-handed. How do you think that the defense is going to use the hospitalization of Floyd for an overdose the previous month as a defense against the argument that since Floyd is a heavy user, he wouldn't necessarily die from the level of fentanyl in his blood? So okay. So I see what you're saying. So the previous month hospitalization as a defense to the argument that since Floyd is a heavy user, he wouldn't necessarily die from the. So I think it's a matter of timeline and interpretation. So I'm not real clear on this timeline, but based on another comment we got today during this show, somebody said that the girlfriend testified that he had been clean for 2 weeks, which I don't remember. I might have missed that though. So if he was in the hospital, let's say last month, that gave him a little bout of sobriety for, I don't know, the following 2 weeks. Then this happens. He may have had a relapse, right? I mean, it could have just been a timing thing. So I'm not real clear on the timeline, but it's a good question there. Ham-handed. No Doubt says, with home detention, does it frequently permit going to work? It does actually. Yeah. So home detention is sort of like, the way I explain it often to people is it's like jail, but kind of at your home. And even in some jail situations, they will let you have work release. So work permits. So let's say you get charged with a DUI in Arizona. It's your second DUI. You have to go to jail for 60 days. They're going to let you out for work, but you got to report back to jail. So you leave for work, go back to jail, spend the night, go back to work. You can do that 6 days a week. 7th day, you stay in custody. Same type of thing with home detention, except instead of reporting to jail, you just report back home. Much, much preferred. Sharon Quidney says, is it totally out of line to call these folks political prisoners? This is the kind of thing that used to take place in Stalin's Russia. Guess it's appropriate to call Biden Uncle Joe. Yeah, I mean, look, I don't disagree with that. I mean, I think that they are the subject of a very coordinated political prosecution. I'm not sure what else you can call it, quite frankly. Next up, Kelly Stu says, can these folks sue for rights violations once they are let go? They can. I'm not real sure that they're going to get anything out of that. You know, it's going to cost a lot of money. I'm sure there's some lawyer somewhere who's willing to fund this thing. I think it would be a good thing to explore. I'm not sure. You know, I don't do civil lawsuits. Quite frankly, I just don't do them. And we refer any of our civil suits out to other people. So I can't really opine on that. But yeah, I think it would be an interesting exploration. And it'd be interesting if there was a way to organize everybody and see how many of these things were sort of happening simultaneously. You know, the government has an unfair advantage in a lot of this stuff. They are the ones who are in charge of prosecuting all of the cases, 250, 300 cases. The defense is a little bit scattered, right? It's more distributed. Every single defendant has their own defense attorney. And so it's kind of hard to tell and synthesize how things are going, generally speaking. The government knows because they're running one division that's leading the prosecution, but the defense attorneys are scattered and distributed a little bit. But if there was a way to organize that and gather all of the complaints, could probably make a pretty compelling civil case, maybe a class action, something or other, but that's just not my area of expertise. But good to see you, Kelly. We got _shade says, Sullivan got out fast, paid thousands by media, interviews all over. Can't the other lawyers use that example to help get them off too? Madness. Yeah. So I think other attorneys will absolutely lean on this precedent as guidance and say, look, you know, you guys are being ridiculous. I know you're very upset about this. I know this keeps you up at night. You think that that America was about to be seized by the QAnon shaman. Probably keeps you up at night. I know how traumatic that is, but this is not right. And the judge is correcting that. And other defense attorneys, I'm sure, will take that and run wild as they should. Osak says, want to give you and your law firm a big thank you. I had some prior legal issues, so took your advice and called your firm. You guys were able to answer all my questions and give me great sound advice on how to handle my issues. Also, Miss Faith did a follow-up with me just to check to see how my went and if I had any other questions. Great to see people like you do care. Keep it up. Thanks again. Well, Osak, that's so nice of you, my friend. And we didn't even pay you to say that, did we? You should have added that in there. This message has not been sponsored by the R&R Law Group. And I kid. I mean, honestly, that's a very nice thing to say. I'm glad we were helpful. Miss Faith is amazing. We have an awesome team of people here. I don't just say that. I mean, it's actually true. We have everybody's super passionate about helping people, and that's taken some time to curate a good group of people and, more importantly, build a culture that is conducive to that environment. There are a lot of other law firms out there that they just kind of run their shop like a mill and people just kind of get ground out. I know that because I used to work at 2 of them before we started this company to do things differently. And it's nice when I get feedback like that it works. And I appreciate that. And thank you. Thank you for communicating that. All right. And that was the last one for that segment. Glad it worked out, Osak. Appreciate you being here. You're always here. It's such a nice thing to say, so thank you for that.